Hi everyone. Today I would like to talk about as a part two um, towards philosophy of law. Okay, so just a quick recap: jurisprudence or philosophy of law is studying what is law, um, what is the rule of the law, what does law has to have in order to be a law, what elements does it have to have morality? Does it have to be removed, far removed from morality? As we have seen some legal systems through history, for example, like Nazi legal system, which was removed from morality, and then we also had a legal system that has positive law, which is positive law is by definition a law posited by men. Like, for example, Constitution, the United States Constitution, or let's just say United States Constitution is written and posited as men have written it and have used different documents. For example, founding fathers came up with the different ideas using some of the 15th, 16th century, 17th century, 18th century philosophers that had written so much on what kind of government we should have. But the law is, in a sense, philosophy of law has many different approaches to it. For example, Oliver Wendell Holmes thought that law is the predictions what the courts will do. Well, if that is actually really true, so when you hire an attorney and you read the law and you say, well, I can predict you will win this case. So I don't know what Oliver Wendell Holmes courts will. The law is a prediction. What the courts will do is never a prediction, because we can, if an attorney, if you're hiring an attorney, that attorney tells you you will win this. I would looking into different attorney, or I would look for the second opinion. So, but this that was called legal realism. What Oliver Wendell Holmes was talking about, and he was discussing it in the sense that we have a law that is going to tell judges what to do. Right, we do have the law, but then we have you can have two competing attorneys who have, or lawyers who have the idea, who have cited both precedents, who are equally powerful, and then the judge has to decide which precedent to follow. So in fact, the case that you choose as an attorney might be 50-50% of going one way or the other. So there is no prediction, unless you bribe a judge or something like that. That's different. But what I'm saying is that in legal philosophy, jurisprudence, it has many definitions. It's been developed by H.L.A. Hart. It's been developed by Alon Fuller, Ronald Dworkin, the Richard Posner, all these different judges and thinkers. We have Jeremy Bentham. We have John Stuart Mill. I mean, you name them. All these different people have different approaches to what philosophy of law is. Immanuel Kant, John Stuart Mill, but David Hume, John Locke, founding fathers. They all have kind of different idea, yet founding fathers have built their own legal philosophy based on what they were reading, based on John Locke, David Hume, Montesquieu, and all that, as I talked about earlier. But I want to talk about two major important distinctions between positive law and natural law. They're two different, at least theoretically speaking, they're two different ideas. Positive law, as I said earlier, is a law posited by men or women, or both. And those are the laws, like, let's say, rules of the road. Those are the rules created by men, and that's called positive law. But if we talk about a natural law, which is considered to be revealed law, revealed by God to man, and then man writes it down. Well, you can theoretically speaking, this is based on, I think mostly based on John Locke's theory of natural rights. It, just like it says in Declaration of Independence that we have rights, inalienable rights, right to pursue happiness and religion and all that. Those are the rights that were God-given to man. And these rights cannot be taken away from. Well, at least that's the theory about it. So the natural law is, in a sense, revealed law, that it's divine law revealed to men, and then men write it down. It sounds like a prophet, something like when Jesus or Muhammad or Messiah and all of them claim to be, talking to God, and the God revealed it to them, and they wrote it down as commandments, and something that has major influence on natural law and natural affiliations. But what I want to talk is that law is law. I just, for my purposes, that this is why to explain the difference between natural law and positive law. But philosophically speaking, there's no difference. They were both natural law and natural rights, and were written by men, mostly by men. And Montesquieu and John Locke and all these that we're talking about, Thomas Hobbes and all that. Well, Thomas Hobbes had a little different view, but these rules were not revealed to anyone. I think they just, after many different studies and many different thinkers were writing things down, and that's how the United States Constitution was built, based on these rights. So the major fundamental difference between positive and natural law is that natural law and natural rights are inalienable, and you have a natural right to pursue property, to pursue happiness, which is, I believe in Jefferson's time, pursuit of property and pursuit of happiness was the same thing. Of course, at that time, if you were, African American, you couldn't, if you were a slave, you really actually couldn't, you did not have that kind of right. And so the natural right, which is one fundamental element of natural rights, is that all men are created equal. Well, history tells us that's not what humans were thinking, and this is too ideological a view, because people always think of themselves as superior over the others. Positive law, on the other hand, is a law, as I said, posited by men, meaning men studied and interpreted and all that stuff. But we can see that there is that difference, that it is revealed law, but yet we do not have any evidence of revealed law, or law that's been revealed to men by any other mediums or any other prophets or anything like that God spoke to them, and this is the laws. Yet positive law is something that I would like to discuss, because positive law is something that we are all binding by today. Yes, there have been major influences on positive law by natural law and religious law and through the history. But in terms of United States Constitution, all these different elements were taken and put together. Like, so we have, 10 amendments, right to free speech, Second Amendment, Third Amendment, Fourth Amendment, all these different amendments that became natural rights. And then we had a 14th Amendment, which is, which ensures the due process of laws taking place from it's like a federal oversight over the state, how the states have implemented or have used, or if you feel like that your rights were violated, and you have a protection on the 14th Amendment to ensure that these rights were not amended. So let's say right to an attorney, that's positive law. That hasn't been revealed, the Jesus didn't come down and say, hey, you have a right to an attorney, or any other prophet. So this is the idea. So this is it's a positive law, and cases that, let's say, a Supreme Court enacts, like just a recent case in the LGBTQ community, that's positive law, and all that. So they realize that people have all equal rights, and in terms of, and that you cannot discriminate against any minority or based on race, gender, and they define gender to be also part of the LGBTQ community. So you see how the positive law changes, and so the positive law is something that today we make contract. A contract that two people make, it becomes a contractual law. But the idea of contracts is posited by men. This is something that we need to think about as natural rights. Natural rights come from natural law, but there are certain rights that we know that rights by Constitution that were posited by the United States Constitution is that you have a right to an attorney, you have a right to challenge the witnesses, you have a right to confront witnesses, you have a right to question witnesses if you're going under trial. All these things that were implemented are positive law. This is not natural law or anything like that. As founding fathers, and it's, I think founding fathers and all these, like John Locke, who is heavily influenced by religious thinking and all that, but at the same time, natural. We can say natural if I define it in a different sense. It is natural for me to defend myself, right? So self-defense. But at the same time, you have rights that could be taken away from you, like pursuit of property. And they said that pursuit of property, right? But eminent domain, if government thinks that your house is in the middle where they're going to build a railroad, well, for that, your private property could be taken away from you. They could give you some money for it, and that's called eminent domain. So I don't want people to think that because these rights, when you go through the system, you'll see that these rights are very hard to defend and define. All right, so far, they are easy to define, but hard to defend, because the definitions we give are too rather idealistic to stand in court of law or in all that, because you have all these, these sections, or let's say, just simple one, freedom of speech. You do have freedom of speech. You can stand on the street and you can say whatever, this, that, but if you go in a movie theater and you say fire, that's not considered freedom of speech, because you're creating imminent, clear present danger test. That is how one way a First Amendment used to be measured, based on a clear present danger test. So all these rights have certain tests that they have to pass through, and if you think you have a right and you've been discriminated against, you have to show that all these different tests that apply to your right are passing through, and you can pass through those tests in order to ensure that this is your right, if that makes sense. All right, so far that's it for right now. I'll talk more about philosophy because this is one of my favorite subjects, and we will talk I will talk more about the positive law and natural law, of course. All right, that's it for right now. Take care.